Hi, everybody, and welcome to today's presentation. It's my privilege and pleasure to introduce Gray Edmondson. Gray is a partner with a law firm of ESA Law in Oxford, Mississippi. Excellent tax attorney and ACTEC fellow, does a lot in the tax and tax controversy and trust and estates world, and actually has a great blog on his website giving you updates on what's new in the tax and corporate and trust and estates worlds. So I'd encourage you to read those resources after the fact. I'll link them in our video notes below. But for the time being, thank you, Gray, for joining us today.
Gladly, I appreciate the opportunity to be here.
Absolutely. And today we're going to kind of dive into a hot topic in the trust and estates world that what Gray and I were discussing tends to fly under the radar. Everybody likes to assume that things work a certain way when it comes to the intersection of powers of appointment and fiduciary duties of a trustee, especially when the trustee wears two hats as being both trustee and beneficiary and or holder or donee of that power of appointment.
Yeah, and I'd say that that's really what this issue is about, is the notion that we often, when we design trusts, give an array of rights and powers to certain individuals. The same individual may be a beneficiary, may be a trustee, and may hold powers to appoint trust assets. They may hold the power to remove and replace other trustees. So they may hold an array of rights and powers, and how do those differing rights and powers interact with one another is sort of what the issue we're discussing relates to.
Yeah, exactly. And I think as a good introduction, it's helpful to kind of separate out the power of appointment from a tax law perspective, which we won't dive into, versus the power of appointment from a state law perspective, which is really what we're examining today, because tax law doesn't care whether it's a fiduciary or non-fiduciary power, but at the state law level, that's a big deal. And it could really affect the liability of the trustee who's also wearing that hat of holding and exercising a power of appointment.
That's right. And really what we've identified in the materials that you're going to link, in the under the video, is that the common law has recognized for the longest time sort of powers of appointment, which is a power to appoint trust assets to someone held by either a trustee or a non-trustee, a beneficiary, or a third party. But someone's granted a power to appoint trust assets, is what a power of appointment is, and has recognized that that can be held in a fiduciary capacity or a non-fiduciary capacity. And of course, when you think about it, any trust that says a trustee can distribute for the beneficiaries in the trustee's discretion, or for health, education, maintenance support, or whatever, that is a power of appointment. It is a power in the trustee to appoint trust assets subject to whatever standards in the document, but that's in their capacity as trustees. So, right, that's a fiduciary power. But oftentimes we'll grant those powers to, say, a beneficiary or a third party and say, you're not trustee, you're not in a fiduciary role, but you have a power to appoint assets in your discretion without, presumably, and the intent would typically be, without the constraints of a fiduciary obligation to any beneficiaries, current or future.
Exactly. And the hope here, it seems on its face, is that you can create what in most circumstances should have been an outright distribution, but with the hope of capturing some of the benefits that you get under creditor protection law and tax law for trusts, but without layering it with a ton of fiduciary duties and baggage, if you can put it that way, that comes along with having a trust put in place.
And that's right. We oftentimes, when we're meeting with clients, discuss the benefits of keeping assets in trust. And those benefits can be protection from creditors, protection from future divorces, be that a surviving spouse or a child or a grandchild or any other beneficiary, be that Medicaid planning, say for a surviving spouse, any number of tax planning to preserve generation skipping tax exemptions, any number of reasons why it makes sense to preserve assets in trust, when otherwise that client, that settlor of a trust, would have just made an outright distribution. And so what you're trying to do very often is get the benefits of retaining assets in trust while mimicking outright ownership as much as you can. And one of the hallmarks of outright ownership, of course, is you can do with those assets whatever you want. And so when we give these powers of appointment to this beneficiary, the intent is to say, you can exercise that power free of any fiduciary restraint, because you could have done that if I'd have given that to you outright.
Exactly. And, we've linked the article below. I'd encourage you to give it a good read, but that really kind of highlights from a factual perspective some classic disputes that may arise with any sort of trust or inheritance or anything like that. One being between surviving parent and children, because children hope to get everything at the surviving parent's death. What if they don't? What if it's redirected elsewhere? Another dispute could arise between maybe children and surviving parent, and maybe a disinherited heir. So you've described some great cases in the article below. We won't dive into those in specific detail, but maybe you can kind of give a general 30,000-foot view of each, and what the court concluded, whether rightfully or wrongfully.
Well, that's right. And I think really what a couple of the cases that are cited there, and one's a case from Georgia, that's a Peterson case, and one's a Tubbs case or Berkowitz case from California, but they essentially deal with the same thing. You've got a settlor who set up a trust for their surviving spouse, named that surviving spouse as trustee, and gave them a power of appointment, right? Similar circumstance under either one, but we have two state courts coming to 180-degree opposite outcomes. And so the question becomes, when that surviving spouse, who's also serving as trustee, exercises a power of appointment to effectively disinherit one or more of the children who would have been, in the absence of that exercise, a beneficiary, are they constrained by the obligations they hold as trustee in the exercise of that power? And so I believe, and I cited the materials that we've discussed, some restatement of law provisions, some uniform trust code provisions that seem to, or comments to the uniform trust code primarily, that seem to indicate that you can exercise non-fiduciary powers separate and apart from your fiduciary duties to a beneficiary. But the Peterson case out of Georgia, the court actually found the other result and said that this surviving spouse, they had duties to act without bias, without partiality, to act in good faith, and those types of things towards these default remainder beneficiaries. And when they disinherited them by their exercise of their power of appointment, they breached those duties because they were biased towards the beneficiaries they exercised that power in favor of. And so real big concern there, of course, is when these situations, as we've discussed a minute ago, where we create these trusts with an intent to mimic outright ownership, to give these powers free of fiduciary constraints, but also name that beneficiary as trustee, again, to give them as much flexibility as possible. If they can't exercise those non-fiduciary powers effectively without breaching their fiduciary duties, our whole plan is undone. Right.
Exactly. Yeah. And it kind of dawns on me looking at that Peterson case that there's a couple hot button issues. One is, a lot of times we like to use testamentary powers of appointment, but there's a difference between a testamentary power, which you exercise at death through a will or other instrument, versus a lifetime power, where essentially you have the ability to take assets out for yourself without any fiduciary duty or constraint or anything like that. And it kind of seems that was the case with a couple of these case opinions, and the court didn't really draw that distinction as well. But I think that's meaningful to us as trusts and estate planners, especially.
Right. Well, I think one of the conceptual questions there and what you're discussing is, when you are serving as a trustee, can you ever take off that hat as trustee? Or are you forever in everything you do, 24/7, 365, every decision you make, constrained by those fiduciary duties because you're a trustee and you can never shed yourself of that responsibility? And I think there's case law, and there's a tax opinion that I cite in the materials, the Frank Aragona trust case, that deals with a separate issue, but it seems to recognize the notion that you can't ever take that hat off as trustee. You always owe that duties. But from a state law perspective and from a trust administration standpoint, when you're granted fiduciary and non-fiduciary capacities, sure, you may always be a trustee and you always may be subject to those duties, but this particular power is granted specifically in a non-fiduciary capacity, right? But
exactly.
How does the fact that you're always a trustee interact with non-fiduciary powers held by a trustee, right?
Yep.
And that's really the conceptual issue in all of this.
Yeah, and there's a lot to be gleaned from the intent of the settlor, the creator of the trust. And it seems like in this Peterson case, the court relied on that a little too much and focused solely on the intent in creating the trust, not necessarily the intent and also granting a power of appointment, which might have run contrary to the apparent purposes of that trust.
Well, it actually appears that the court there imputed intent that might not have necessarily been outright stated in saying that settlor intended to benefit all of their children because they were all default remainder beneficiaries, and so they must have intended that. And that may be true, but if they had intended for that to rule the day, they wouldn't have granted the spouse the power to begin with, right? And so,
very true.
Sure, they intended to benefit their children, but they also intended to allow that benefit to be subject to the rights of the surviving spouse to exercise the power of appointment as it was granted, which I think points to one of the lessons out of all of this is when you intend to grant powers to someone who may be serving as trustee, but you want them to exercise those powers free from those fiduciary responsibilities, is to state that that's your intent somewhere in the document, right?
That's a good
point. I grant this power in a non-fiduciary capacity. That is the settlor's intent to not hold them to fiduciary responsibility in the exercise of this power of appointment. And that way, if these cases are primarily being adjudicated after the death of that power holder, right? And so not all of these were, but very often they are. And so, and not just the power holder, but the settlor who granted the power, right? And so I think in drafting the documents, it's incumbent to make clear the settlor's intent that although they may be serving in a fiduciary power capacity, this power is a non-fiduciary power.
Yep, exactly. And there's some parallels to be drawn here too. I think, there's a lot of talk out there about the bifurcation of the trustee role, but in a sense, this, the whole purpose behind that is splitting out or limiting fiduciary duties. But in a sense, this is a parallel type of structure. And I think the Tubbs case really went to the fact that, yes, you have fiduciary duties that you can never get rid of, but, they are kind of a fiction, if you could call it that, in this type of circumstance. When it
right,
comes
and that
to
was the argument that in that Tubbs case was that if you can take your hat off as a fiduciary at any point, then what is and you can exercise these powers of appointment free from any obligations, then what does it even mean to be a trustee? I mean, what is that, right?
Exactly.
If you can exercise your powers free from that responsibility. And so I think that's the question, right? I mean, what's your ability to take that hat off and exercise non-fiduciary powers? And I think the common law in the Uniform Trust Code seems to recognize that you can have a distinction there, even if you're still always a fiduciary and always subject to those responsibilities. That doesn't mean you might not have certain powers granted free from those responsibilities to beneficiaries. I think the law recognizes that. Obviously, Georgia appellate courts disagree with my theory, at least on the facts of that case. And there could have been some factual things going on there. It appeared that was in the context of a family ongoing dispute where it may have been exercised sort of vindictively or something like that, that gave the court a little bit more from an equitable standpoint reason they felt that it was necessary to reach that conclusion. And there's always what you read in the opinion and what you don't read. So
exactly. I read a lot into opinions, and it sounds like you do too, but there's always unstated facts.
Right. And I feel like in that case, there may have been sort of a spiteful, vindictive type feel to what was happening, whether that was present or not. But I get the sense the court felt like that was going on.
Exactly. And we kind of get down to the end of things, flipping the switch. You brought up good drafting and the lesson of emphasizing that non-fiduciary aspect. But I'd also kind of emphasize too, maybe give thought to, if you're disinheriting an heir, don't include them in the class of donees under a power of appointment.
Well, that's
right. You don't
right.
want them to benefit down the road. And that's exactly what happened in Berkowitz. Whether it was intentional or unintentional, we don't know. Once again, reading into the facts, but that's ultimately what happened. Maybe give a little color to that. And
well, I think that's sort of relevant also in the Ferguson case, which I mentioned in those materials. And it really becomes at what point someone becomes a beneficiary when you exercise powers of appointment. And so if you have a default beneficiary, which we're always going to have, who takes in the absence of exercise, right? And who are the permissible appointees. And so at what point do you owe fiduciary duties to someone, right? Do you owe it to the default takers, even if you can cut them as beneficiaries through the exercise?
Mm-hmm.
If you exercise it, do you owe the fiduciary duties to the persons in favor of whom you've exercised the power now, and not the default beneficiaries? And the Ferguson case I mentioned, a surviving spouse exercised a power of appointment to add a beneficiary who wasn't one of the default beneficiaries, but was in the class of permissible appointees. That beneficiary sued for information under the inform and report statutes that are under the Uniform Trust Code, and said, I'm entitled to information. And the question became, does the trustee owe duties to you yet? Because you're not a default taker. You're an appointee under a power of appointment exercised under a will, which of course, those of us who understand how wills work, they're referred to as ambulatory documents, right? They don't speak until your death. They really are nothing until then. But the court there found that from the date of exercise, you owed that person duties. And so to your point, Griffin, is do you carefully select who you name as remainder beneficiaries as a default taker? And when you exercise your power to manage when fiduciary duties become due and to whom they're owed as a default. And I've actually had somebody mention before as a concern with children who were litigious to say, let's just name a charity as the default taker. Forget it.
That's a good point.
And that way we'll have the surviving spouse immediately after the death of the first spouse, or immediately after we set up this trust, go ahead and sign a new will exercising the power. But presumably their duties would only be owed to this charitable remainder beneficiary and not to these unnamed children.
Yep, exactly. And I think that's the great irony in this Ferguson case is it really, in a sense, expanded fiduciary duties. And a lot of people would be surprised to find out, oh, guess what? Now you've expanded your duty of accounting simply by virtue of executing a will and naming a permissible appointee in this power of appointment.
And I just think that court got it wrong. I mean, I think if it's an ongoing trust that you have a lifetime power of appointment and you exercise that to add a beneficiary from that point forward, well, then potentially, yes, they are now potentially beneficiaries to whom you owe duties. But if it's a testamentary power that you're exercising in a will and that will doesn't speak until your death, I fail to see how that person is a beneficiary who has rights to fiduciary duties until your death, because that will could be revoked, it could be amended, they don't become entitled to any distributions, nothing happens until your death. But the Ferguson court found otherwise. And so, we can all sit here, I think a lot of us, myself included, get real sort of comfortable that we know what the law is, and I can read the restatement and I can read the comments to the Uniform Trust Code and I know what this is and here's my rights. That doesn't mean every judge in every court out there is going to understand this. Not all of them are trust lawyers, right? And not all of them understand the nuance of some of these distinctions. And fact patterns are messy. And so, what we can sit on panels and discuss about, you can get comfortable doing this, the law supports it, doesn't mean that that's really always going to win the day. If you'd have asked me what the outcome was going to be in a couple of these cases before they were rendered, I probably would have told you the opposite of what ended up happening.
Exactly. And, unfortunately, in some of these, I think like in Peterson, the Supreme Court didn't grant cert. So there was no second set of eyes.
That's right. And so, I think that gets back to the drafting standpoint is we can all be comfortable and confident that we know the law and that we believe we're applying it correctly. But that doesn't mean every set of eyes that looks at this and that it interacts with what you set up is going to see it the same way you do or have the same background you've got or understanding you've got. So it gets to in drafting choices that you make and what you say in the document, what default beneficiaries you put, when you exercise powers of appointment, all of these different variables that go into the drafting process. Consider the fact that there may be eyes looking at this that don't see it the same way you do.
Exactly. Yeah, much like you have to explain things to a client, sometimes the judge is equally
That's
as
right.
misinformed about trust and
Well,
estates
that's
law.
right. And most states around the country don't have courts that are unique to probate and trust and estates. I mean,
Hmm.
some courts have some states have courts that are relatively unique for that. We in our state of Mississippi have courts of equity that are unique to trust and estates, but they also handle an array of other issues, family issues, boundary disputes, these kind of things. And so, the judges in these courts aren't necessarily well versed in trust law, and they didn't spend their time as practicing attorneys necessarily handling trust work all the time. They spent their time doing divorces and boundary disputes and land issues and these kind of things.
Hmm.
And so, you have to use the way you draft and the way you set up to educate them about the intent, because I think most of them at least understand settlor's intent is paramount.
Yep.
Right. So if you can educate them about that when you draft the document, then that may go a long way towards enforcing what you're really trying to establish.
That's a really good point. And I guess with that being said, we've highlighted some great lessons and takeaways through this, but wrapping up, what are kind of your big takeaways and lessons for the viewer here? And what should they take away from these cases beyond the obvious in the facts and the article and everything like that?
Yeah, I think my big takeaways are a few things. I mean, in one is no, as I just said, that not everyone's going to understand the law the way you do, or maybe you don't understand it as well as you think you do, or whatever. I mean, know that just because you are comfortable with what you believe the law is, others may see it differently, and so you need to be conscious of that and not just rest on your laurels and assume you know the outcome. Right? That's not always going to
Hmm.
work out that way. And then the other primary takeaway, I think, is in an understanding that draft and create your structures with that in the back of your mind, knowing that someone else might not see the law the same way I do, or someone it may not have the same understanding we've got, or know this settlor's intent. And so educate through your drafting, or strategically grant powers and exercise powers at a time that's going to mitigate against contrary arguments, and being contrary to what the intent is, and then establishing the structure. And I think when you go into it with that mindset, you set yourself up to be as successful as I think you can be.
Excellent. Yeah, great points. And Gray, thank you so much for your time today and your insight, and for this great article. You've given me a lot to think about, and I'm sure you as a viewer, you've probably had some great takeaways from this presentation as well. But thanks again. I'll link Gray's information below. You can check out his website at esapllc.com, 2 L's, not one. And if you have any questions, I'd encourage you to follow up with him, because he's more of an expert on this than I am. And I thank you again for joining us today, and I look forward to seeing you in our future content.
Thanks for having me. I appreciate it.
Thank you, Gray.